My name is Michael Kennedy, and I am an attorney and senior partner at Estelle and Kennedy, a full-service law firm with offices in Upland, Los Angeles, and Mission Viejo, California. Today, I will discuss new California employment laws affecting salary information, criminal convictions, bonding time, and immigration status in the workplace. This discussion is not intended to be legal advice for any particular case, but is intended as general information for public use. The California Labor Code is a comprehensive statutory scheme that governs the obligations of employers and the rights of employees in the workplace, including employee personnel, payroll files, meal and rest breaks, and other requirements. These laws are very complex, and the failure of an employer to adhere to them can result in significant legal liabilities. Recent laws have been enacted that California employers and workers should be aware. One such new law prohibits an employer from 1. Seeking salary information, including through an agent, about an applicant, and 2. Relying on the salary history information of an applicant as a factor in determining whether to offer the applicant a job or what salary to offer the applicant. The new law also provides that, upon reasonable request, an employer must provide the pay scale for the position to the applicant. The law does prohibit an applicant from voluntarily and without prompting disclose his or her salary history, and if he or she does so, an employer is not prohibited from considering or relying on that information. However, the law provides that a violation of this law can subject the employer to monetary penalties. California has also enacted a so-called ban the box law, which governs the use of a job applicant's criminal history. The new law prohibits employers with 5 or more employees from asking about criminal convictions on employment applications, asking applicants about criminal convictions prior to making a conditional offer of employment, and also prohibits employers from considering or disseminating information about an applicant's prior arrest that did not lead to a conviction when conducting background checks. The law does not prevent employers from ultimately deciding not to hire an applicant with a criminal conviction, and consideration of an applicant's criminal history will be permissible only after the employer has made conditional offer of employment. However, should an employer decide not to hire someone who has been convicted of a crime, the new law requires that the employer engage in individualized assessment that justifies that decision. An employer's assessment must include an evaluation of the nature and gravity of the offense and conduct, the passage of time, and the nature of the position sought. The employer must then take other procedural steps, including notifying the applicant of their preliminary decision, give the applicant a copy of the conviction report, if any, and explain the applicant's right to respond within 5 business days. An additional 5 days is added if the applicant notifies the employer that he or she intends to respond to the notice. No action can be taken by the employer during this period, and the employer is required to consider the information provided by the applicant before making a final decision. Now, if the employer ultimately decides not to extend an offer of employment, the employer must notify the applicant in writing and, among other things, provide notice to the applicant that he or she has a right to file a complaint with the Department of Fair Employment and Housing. Another new law now requires California businesses with at least 20 employees to provide 12 weeks of unpaid and job-protected family leave to bond with a new baby or child within 1 year of the child's birth, adoption, or foster care placement. This is a decrease from 50 employees under previous law. To take family leave under this bill, an employee must have at least 12 months of service, have worked at least 1,250 hours during the previous 12 months, and work at a work site with at least 20 employees within 75 miles. Employers are also prohibited from interfering with or denying an employee's right under the new law. Another new law, and this is particularly interesting, it addresses a business's duty concerning how to cooperate with immigration enforcement efforts. In California, an employer may not allow immigration enforcement agents to access non-public areas of the employer's workspace without a judicial warrant, nor may business voluntarily permit an immigration enforcement agent to access, review, or obtain employee records without a subpoena or court order. In addition, the new law requires an employer to post a notice advising of an impending inspection within 72 hours of the employer's receipt of such notice, and provide this notice also within 72 hours of receipt to the employee's authorized representative. The consequences for businesses who fail to adhere to this law are stiff and range between $2,000 and $5,000 for an initial violation and $5,000 to $10,000 for subsequent violations. These are just a few requirements that both businesses and workers need to consider when assessing their respective obligations and legal rights that govern the workplace. Estelle & Kennedy is a full-service law firm, and we are here to assist both businesses and individuals navigate this particular area of law. Thank you.